Clause number 2020 CR 1656, State of Texas versus Felicia Ramon. The defendant has pled not true to violation 14B1, which was the violation that she failed to comply with the rules and regulations of felony drug court. A representative for drug court is present. Ms. Zamaroon, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. Could you speak up a little? We're having a hard time hearing.
Yes, ma'am. Can you
All
hear me?
right. Yes, we can now. Could you state your name for the record and spell your last name, please?
My name is Diana Zamarron. Last name is Zamarron.
All right. State.
Ms. Zamarron, what do you do in regards to the drug court?
I'm the court manager for the felony drug court.
Okay, and do you interview the possible candidates for the drug court to see if they can go into the drug court?
You're gonna have to speak up.
Yes, if necessary, I do. But we typically have an assigned person to do screenings.
Okay, and were you the representative from the drug court who had an opportunity to speak to Felicia Ramon?
No, that individual was licensed professional counselor Elsa Guajardo, who is one of our case managers.
Okay. Can you look at the notes that your case manager entered in on this case?
Yes.
And what do those notes indicate?
The notes indicate that she met criteria for the drug court, and that the client voiced she did not want to participate. Ms. Guajardo noted that she lacks insight into her addiction and feels that she can stay clean on her own. Her drug of choice is methamphetamine, and she minimized the severity of her problem. She wrote her drug of choice is THC on the information questionnaire. But after she spoke to Ms. Guajardo, she asked her to be honest, and so she gave her more information about the methamphetamine use, which was IV daily before her arrest on 4/1/2022. She expressed she did not need drug treatment and could not remember when she was admitted into Laurel Ridge Treatment Center. She denied any mental health history and at times could not keep her story straight. Her 3 minor children live with her father, who has full custody. She denied any out-of-county cases. She was homeless when arrested and stated that she can come and go from her mother's house anytime. She is at high risk to go back to her active addiction and will benefit from either residential treatment or intensive outpatient if she is willing to show up and participate.
Any other questions?
Pass the witness.
All right, defense.
Yes, and she said that I didn't tell her, I didn't tell her about it. And that's the reason. I did tell her at the beginning of the video.
You'll have a chance.
Yeah.
I have no questions for her.
All right. Is this witness excused or subject to recall?
I'm sorry.
Excuse me, Your Honor, excuse.
All right, Ms. Zamaroon, here's the question. If, and I'm not saying I'm going to continue her or not, I'm not saying if I'm finding this true or not true yet, but would she be welcome back into felony drug court? Or are you all full?
Judge, we will definitely make room for her. She needs the help.
All right, thank you so much. It's appreciated. All right.
Your Honor, I would call Ms. Ramon.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand.
Can you state your name?
So you should,
Yeah, you just heard the testimony from notes that you refused and indicated you did not want to participate or needed drug rehab. Do you recall that conversation?
No.
Did you meet with someone from the felony drug court?
Yes.
Do you remember who that was?
So it was a lady, I don't remember her name, but I see her.
And did you cooperate in answering questions and participate in an interview? Let me talk. Go ahead.
Yes, I answered everything honestly the first time. I never hesitated in telling her anything that I was doing. She asked me one time and I told her, and she never went back to do it again. And at the end, I never told her no. I never told her I didn't want to do it. She left and came back and told me that based on the question and the answers that I didn't qualify, like, I did have to do it, and then, I did something there telling her about I had probation, but I never told her no, that I didn't want to do that.
At the time of the interview, did you believe that you had a drug problem?
I mean, I know that I do, I know I did it the worst kind of way, but I'm
Ma'am.
not.
Sorry, if you'll face me when you're talking. I can
Oh.
speak.
I know I did the worst kind of way, but I didn't. I mean, I know that I guess it's called a problem, but no, I'm not like.
Here's the question. Let me just cut through all of this. Number one, the whole issue is a witness has just testified that you said that you didn't have a drug problem and you don't want to participate in felony drug court. So here's the second question for all parties here. If she is now saying that she wants to participate in felony drug court, one, state and defense, are you all in agreement to her going back to felony drug court? That's the question, because she has not said anything to completely address what the witness has said.
Well, she wasn't there that week, and I've never talked to her at all.
No, here's my question. They said that you didn't want to participate in felony drug court. The answer to that is either yes, you do, or no, you don't. And let me give you some.
Do I want to do it now?
Let me give you some choices. Here are your choices. I can revoke you, send you to prison for 6 years. You can go do your time and live the best of your life, however you want to live it. Or either if the state and the defense and probation are in agreement to you going back to felony drug court, you will be going back to felony drug court. Those are your choices. Do you want to finish questioning her?
No, you're on.
Yeah.
Okay, it seems like she's not taking this seriously.
I just don't want like to be here longer already. You know what I mean? If I would have, I would.
No.
if I was
Here's the
there
thing.
already. And
How old are, well, you, stop. How old are you?
I'm 31.
All right, you know why you're not there already? Because you told them that you did not want to be in felony drug court. We're not playing these games.
I know, but
So here are your choices. Your choices are either you can go to prison for 6 years, or if your attorney and the state and probation agree, you can go back to felony drug court. So either way, you're not leaving this courtroom today. So do you want to go to prison, or do you want to get treatment for your drug issue, which obviously you have a lot of drug issues because your father would not have custody of the children that you should be raising. So what do you want to do?
whichever one.
All right, is there anything else from either side?
Yes, I would have just told you.
No, there's no, I guess I'm going to drug court, because there are other people who feel as though they have a problem and they want help with their problem. And so they go to drug court when I send them there and they participate.
I did, ma'am, and I'm telling you, she told me I didn't. If I knew, like, I've already been in here 3 months almost since drug court. And if I would have went, I would have already been done with it. I never told her no. I mean, I don't have a problem going back, but
Drug court is 2 years, so you would not have been done with it.
No, I'm not talking about drug court. I'm talking about going to like one of those facilities or something, you know. I would have already been on my gun with it, and then I would have continued with the probation. And but I never told her no. That's what I mean. I'm fine going back to it. But I'm just saying, like, I never told him no. That's why I don't understand. I would have already been gone.
I believe it's, is there any other evidence that anyone wants to present?
No, you're on.
All right, I'm finding it true. 14B I1. So now the next question is whether or not you want to go to prison, because you can go to prison and do your time. And then I will move on to the next case, and somebody else can be in felony drug court who wants it. Felony drug court is at least a 2-year program. And it appears to me, based upon what you've said to me and based upon the information I've received from the witness, you're not finishing that program in 2 years. You're going to be a person who it's going to probably take at least a year before you even understand the program and understand that you have a drug problem.
Okay.
So you're probably going to end up in there for probably 3, maybe 3.5 years before you get the program. So
I'll go back.
So you guys want to discuss whether or not you are in agreement to her going back to felony drug court?
One moment, Your Honor.
Okay.
Your Honor, the state would be in agreement with her going back to the felony drug court.
All right. Then I'm going to deny the motion. She's being referred back to felony drug court. She is to remain in custody until a transfer to felony drug court. If felony drug court doesn't accept her, then she's going to safety. And there's to be no unsupervised contact with minors. And the contact, whoever supervises it, it has to be somebody that's approved by probation. All right, probation, is there anything else?
No, Your Honor.
All right, and I think previously I had ordered field visits, but of course, if she's transferred to felony drug court, they will take care of conditions. All right, thank you. All right, court is calling 2022 CR 6807, State of Texas versus Joey Lee Lissy. Can I have parties announced for the record for the state,
Ryan Grimmer for the state of Texas.
for the defense?
Tim Molina for Mr. Lissy.
And are you Mr. Lissy?
Yes, ma'am.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Lissy, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
This time I did thoroughly, the whole thing, not like when I used to, like when I was younger. I acknowledged everything and I read everything twice and you relayed me perfectly and I did it and I got it.
All right, thank
I did
you.
get it this time, yes, Your Honor.
All right.
Yeah.
And Brenna, I forgot it is Tuesday, so I'm going to talk slower.
Okay, thank you, Judge.
All right. Mr. Lissy, I'm showing you what's entitled true bill of indictment.
Yes, ma'am.
Did you review that with your attorney?
Yes, ma'am. And-
Did you understand it?
Yes, ma'am. I know. No, sir. Oh,
Yes.
I did do some of that, yes, ma'am.
All right. Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge. There's kind of a lot in the indictment. So what the state is doing is we're waiving count one, proceeding on count two, which is a state jail felony. However, with the habitual offender allegation, we're proceeding on that, which would make it a second degree felony.
All right. Mr. Lissy, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am. Yes, ma'am. Yeah, I did. I signed in all the places with him and the lady that came up to me and the other lady that with the fingerprint thing and everything. Yes, ma'am.
All right. So what you're charged with in count two is fraudulent use or possession of identifying information less than 5 items. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
All right. Now, the state has filed in the indictment habitual offender enhancement allegation. If the court finds those paragraphs to be true, then this will bump this up to second degree felony. And then the range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am. Yes, ma'am. I understand it. This time I understand it. A long time ago I didn't understand it. But I do understand clearly this time they beat it into me. I mean, I understand every single part of every single paper thoroughly and I just want to say that I understand it. I do understand it. I understand it, yes, sir. I understand it. Yes, sir. And I'm sorry for everybody that I've I'm sorry.
All right.
You understand?
All right, thank you. If you have a plea bargain agreement with the state, court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am. I don't have anybody more trouble, so I won't do that.
No, no, no. I need you to listen to my question and answer the question that I'm asking of you, okay?
Sorry.
Did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state call, and the right to remain silent?
Yes, ma'am. Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am. Yes, ma'am. Thank you.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Lissy, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am. No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, no, no. Yes,
Are you
ma'am.
satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, state is proceeding on count 2, waiving count 1. You agree that you've been previously convicted of 1 or 2 or more felonies for enhancement. Punishment is to be assessed at 6 years opposed. There's a $500 fine. No application for deferred adjudication. State opposes your application for community supervision. They will take in consideration 2022 CR 2713. Did you understand that to be the agreement? Defense, is that the agreement?
Yes, Your Honor.
State, is that the agreement?
It is, Judge.
Showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes.
All right, you're looking towards Mr. Groomer. He's for the state, so he has no answers for you.
Yes, ma'am.
All right. Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
I'm sorry?
I'm sorry, my mind is going so fast. Can you please say again, please?
All right. Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not.
Then to count 2 in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest. No contest.
All right, state, any evidence to support the defendant's plea?
Yes, Judge. State would offer State's Exhibit number 1 and all attachments.
No objection.
All right, Mr. Lissy, I'm going to show you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, laboratory reports, and judgments? But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Mr. Lissy, with regards to the following paragraphs, which is the habitual offender enhancement allegations, I need to know how you plead. It states, and it is further presented in and to said court that before the commission of the offense alleged above, hereinafter styled the primary offense on the 10th of September AD 2002 and cause number 1999 CR 6294 in Bear County, Texas, the defendant was convicted of the felony of burglary of a habitation. How do you plead to that, true or not true? And also, before the commission of the primary offense and after the conviction in cause number 1999 CR 6294 was final, the defendant committed the felony of assault public servant bodily injury and was convicted on the 21st day of November AD 2013 and cause number 2013 CR 6331 in Bear County, Texas. How do you plead to that, true or not true?
Yes, ma'am. Just need your help with that, ma'am. I'm sorry. Okay.
It's true.
All right, the court will review States Exhibits 1 and attachments. Make sure your phone is off, please. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. Counsel, is a TAP evaluation needed?
I would think to have the whole picture before the court, the TAP evaluation and whatever the mental health evaluations are called now.
Mick,
My client does have a history of mental illness. I have no issues at all with any kind of competency issues or anything, but I do think that he has a history of it and the court would benefit from both those evaluations.
all right, and just so the record is clear, the court is finding the enhancement paragraphs true, each one based upon the defendant's plea of true and also States Exhibits 1 and attachments. The court will order a TAP evaluation and a Mick-Myoff evaluation. All of this will take place while the defendant is in custody. We will come back on September 29th. Defense, are you having any witnesses?
I don't believe so.
State, any witnesses?
I don't expect any witnesses to.
All right, so we'll come back on September 29th at 9 a.m. And at that time, the court will make its decision based upon the PSI report and any other evidence that's presented to me. Do you understand? All right, thank you.